Welcome to Infringe at Your Own Risk.
Hey everyone, welcome back to an all-new episode of Infringe at Your Own Risk with Rand Bateman. I am your host, Mike Leon. Rand here is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to even international companies. And in today's episode, we're going to be talking about trademark disputes and what businesses can do when a competitor starts using a name that's confusingly similar to theirs. Rand, I'm sure you get this all the time. I'm sure we talked about this in the last episode, a little bit of it, but when two businesses do start using similar names, right? What's the first factor that kind of determines whether a trademark dispute actually exists?
Well, the number one factor in a trademark dispute is knowing who used it first. Because the worst thing you can do is if you think somebody has adopted a trademark that's too similar to yours, is run out, accuse them of creating a likelihood of confusion, and then having it turned out that they were using it before you were. Because you've basically set up the claim for them. And it looks really silly if you then go before a judge and say, oh, Your Honor, there's no confusion here, after you sent them a demand letter telling them to stop using the trademark. And it actually happens more often than you would think.
I would love for you said the phrase likelihood of confusion. Can you kind of explain how the analysis on that works? Like, what are some of the key elements that influence that evaluation?
Okay, so one of the fun things about being a trademark attorney is that the courts all use different standards. So the most common standard, the one that's used before the Patent and Trademark Office and the Court of Appeals for the Federal Circuit, which is the appeal line from the Patent and Trademark Office, are called the DuPont factors. And basically they're similarity or dissimilarity of the marks. How similar are the marks? And then basically the nature of the goods and services. How close are what party A is doing to what party B is doing? Third element is the trade channels that they fall in. Fourth is purchasing conditions. Fifth is the fame of the existing mark. Is it well known? Is it Mercedes-Benz or is it Mick's Garage? Other similar marks with those goods. 7 is instances of actual confusion. 8 is length of time and conditions of the concurrent use. 9 is the variety of goods and services which are associated with the marks. 10 is market interference. 11 is applicant's right to exclude others. And then just basically whittled down there. The first two are usually the most important. So you've got a sliding scale. How similar are the marks? How similar are the goods and services? The closer the similarity of the marks, the less similar the goods and services have to be. The further the marks are apart, the more similar the goods and services would have to be. So for example, let's take Acme Company. Acme Company sells automobile tires, okay? And down the street opens up Acme, and Acme is a dairy, okay? Probably a very low likelihood of confusion because most consumers aren't going to assume that somebody who makes truck tires is also providing their milk for the store. But if Acme, the second Acme, is not producing dairy goods, but instead is producing transmissions, okay, that's a lot closer. So there's somebody producing a part for a car, another part for a car. Will the public think that the two Acmes are either the same or related, sister companies or a vertical integration or something?
Right.
And so the court looks at those different things. And in some cases, there's one or two things that are going to be really important, and most of the rest aren't going to be as important. For example, I think it was number 7 was actual confusion. Okay, well, there's always going to be actual confusion. There are people who walk into Burger King and ask for a Big Mac. There are people who just get confused easily. So you're usually going to have some confusion. But there's other times where there's a lot of confusion. Company A opens up, they're doing great for 5 years. Company B opens up, and within 2 weeks, Company A is getting a bunch of calls of people who are trying to reach Company B. Well, that's a pretty good indication that the public's getting confused. Sometimes, though, it's also, you look at concurrent use. The two companies have been using the marks for 20 years in a similar locale, and nobody has, there's not many people who have indicated they're being confused. Okay, that's a really strong evidence that there's not a likelihood of confusion. But trademark cases are extremely fact intensive and very subjective. So they're fun. I mean, they're, not often disposed of on summary judgment because of that.
Right. Don't forget that third Acme company with the Wile E. Coyote and the Roadrunner there, Rand. Listen, let me ask you about, let's talk about like if a business gets a demand letter, because I do want to touch on that. So the business gets the demand letter over the name Acme, like we said, or branding that looks similar. What now are the practical steps that kind of help them respond strategically instead of reactively?
Well, first, get as many facts as you can together. Okay. Because, for example, I mean, I've had letters that came in, the client was stressed. They're like, oh, well, we're going to have to rebrand. And I'm like, well, when did you start using your mark? About 6 years ago. And I look up the person who sent the cease and desist letter, and they started using 4 years ago. Well, and tell the client, our response is, thank you for acknowledging that there's confusion. Since we're the senior party, we'll expect you to change your mark. It's one of the things that people rarely do, but when you're adding new marks, keep a diary of them, or some way where we started using the mark on this date. We launched this product or whatever. You would be amazed how many people there are who don't know. And I've had trademark disputes with people who are that both parties have been using it 20 plus years. Right. And then you're going, okay, well, who used it first? And also geographically where you are. Because one of the important things with trademarks is geographic, right? McDonald's Corporation cannot use the McDonald's trademark in several counties. I think it's in Oklahoma, because there's another McDonald's fast food location there that existed before Ray Kroc and his friends started the McDonald's chain. There are people who are made millionaires all the time when a national chain decides to move into a new state. And lo and behold, I mean, this is totally made up, but Anderson Lumber, right? National chain Anderson Lumber, or Lowe's, let's say Lowe's. Lowe's wants to move in, and there is a hardware store there with a very similar name. Well, they usually will just end up buying that person out. And I've been involved in cases where it was a lot of money for every individual in the company, because, the big national company wanted to be in that state, but it would be a trademark infringement for them to come into that state. One of the things that's made this much more interesting now is that little companies can stretch as far as big companies very quickly with the internet. So it used to be you would get a restaurant in Salt Lake City, Utah, right? And they've been selling and whatever, but there's a chain developed on the East Coast, and they're like, well, we're on other sides of the country. No one's going to get confused. No likelihood of confusion. Problem is today is that little restaurant in Salt Lake City is selling their hot sauce to people in Boston and Washington, D.C. and Miami and Chicago. And now you got a problem, because when you looked, you just saw this little store in Salt Lake. It's like, yeah, no big deal. But they've got geographic reach across the country. Yep. And it happens really quickly. And I mean, just in my career time, when I started, it was very rare to get a small company that had a country-wide reach. And now I see it all the time. I mean, companies literally are selling $20,000 or $30,000 a year in product, but they're selling to 10 different states.
Yeah. Yeah, it's more prevalent now for sure. Let me ask you on something that you said there. What tends to happen if a company delays the enforcement part of this and they do allow the Acme spinoff, these competitors, to use the similar branding for too long?
If there's a likelihood of confusion and you sit on your rights, the courts usually won't enforce them. It's the defense of acquiescence. You've known about us for 15 years. You didn't say anything. Um, and I've had one case where huge national company, they've got a brand. Small company has very, very, very similar brand. And but the small company has been selling to the big company for 20 years. So there's no doubt that they knew about it. Sometimes you can get away with, I didn't know, we didn't know this, this little street vendor in Kansas City, Missouri. We've never heard or seen of him. But in this case, they'd been buying the company's products for 20 years. And so it's really hard later on for them to come and say, well, we object to your mark. And you say, but you've known about us for 20 years. You never said anything. So you really can. Trademark owners have a duty to enforce their trademarks. And one of the things, there's a case going right now where the convenience store chain Buc-ee's has sued a company called Mickey's. Well, Buc-ee's has the little beaver, everybody knows. Mickey's has a moose on theirs, but Buc-ee's has sued. Now, on one extreme, you can argue, well, a trademark owner needs to enforce their mark to protect it. This one, I just don't see. I mean, I look at them, I think, how would anybody be confused by those two? But we'll see. It's going to end up being the judge or the jury that this goes before. And I've had cases before where I just thought there's no case here, and a jury goes the other way. Then what most of the IP guys I know, we talk about cases that are kind of high profile like this, and everyone's like, yeah, that's not going anywhere. And then all of a sudden the side wins. So it happens.
Yeah. Beavers and mooses shouldn't be that confusing if you think about it as somebody who just stopped.
Yeah, you wouldn't think, but apparently Buc-ee's feel strongly enough about it that they're going to spend money. So
yeah. Well, let me ask you on that front. What should businesses understand about enforcing their trademarks? I mean, that's obviously more, brick and mortar storefront type stuff, but like with respect to online communities and online disputes, like you were mentioning before, what should businesses understand about enforcing their trademarks in an online environment?
You need to enforce your marks. If you don't, you will lose them one way or another. Either if everybody knows you're not enforcing it, then you're going to get a lot of other people coming much closer to your marks. You've got to, do your due diligence on the enforcement, so you don't make ridiculous claims, because those people can clap back at you for. And you also have to be aware of the Streisand effect. If you get too much of the, overly testosterone litigator who sends out the flaming letter beating their chest, that can blow up in your face. I had a case years ago. I went after a bunch of people who had adopted a mark similar to my clients. The mark had originally been relatively descriptive, so it took us a while to build the name of the mark, but we had pretty solid trademark support. We had multiple registrations and whatnot. And so we sent a demand letter, and people would say, oh, this is ridiculous. You can't do that. But then one of the guys said, but at least the attorney was nice and reasonable about it, right? Which was me. So I felt good because they're bashing the argument, but they're not pointing it and saying, and look what a jerk the attorney is, because that can turn public sentiment against you. And I've seen cases where the attorney was really a jerk, and you get online and everybody's just flaming this company because their attorney was obnoxious in their cease and desist letter. And had they probably would have gotten a better response and gotten the people to stop using the mark had they been, not soft, but polite, firm, but, not we're going to crush you, we're going to put you out of business, that type of garbage, because it doesn't play well to the public.
Yeah. Rand, as we kind of wrap here on this episode, for the companies that are looking to kind of strengthen their long-term brand protection, what are some habits, maybe some best practices that they should start doing in terms of monitoring so that it can help them detect and address the issues and the infringements before they escalate?
So you can hire monitoring services that will ping you when anyone tries to file a trademark registration similar to yours. Um, I would advise your employees, hey, if you see something that you think looks too close to our company, let us know, because your employees are going to run into that stuff out in the public. Um, and then just keep on top of, where are you using your marks and looking. One of the important things when you want to enforce a trademark, if you have a federal registration, but you're only in the Northeast, and somebody in Colorado opens up a shop with the same or similar name, courts are much more reluctant to close that business down, even though you have a trademark registration, because they're saying, well, you're not really creating confusion. So one of the things that you can do preemptively, get your product out there, even if you're not going to have huge sales in California or Colorado or Washington. Get some product into that state so you can say to the judge, well, yeah, we're not in Colorado yet, but we're in Utah and Idaho and Wyoming. We have sales there. And so it's only natural that we're going to expand into Colorado. That's going to be a much more enforceable situation for you than if you're just in the Northeast and the infringer is just in somewhere out west.
Rand, it's great stuff as always. Thanks for the time, the insights, and kind of explaining this to the audience. I appreciate it, my friend.
Thanks for having me.
That's it for today's episode of Infringe at Your Own Risk. If you're working right now to protect your brand or you're trying to navigate a trademark conflict, you can learn more about Rand and his team at Bateman IP by going to batemanip.com. Thank you again for listening, but do me one more favor. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.